Hello, everybody. Welcome to the Bob Unger Show. And we have a very special guest here for a Bravo performance at the opera. He got an encore because he was that good. His name is Edwin Vieira. He's an attorney, and so am I, but don't hold it against us. Doesn't make us bad people. And he has argued cases before the Supreme Court of the United States. He's written books on subjects that range from the monetary history of the United States to all kinds of writings on the Constitution and on law. And so he is certainly, especially by today's standards, quite erudite. No offense on today's standards. Mm-hmm. They're a little lower than the founding fathers, but he's up to those standards, which is highly unusual. At any rate, we're going to get into some issues having to do with the whole controversy over the subject of militias. And recently we had the case of a young man named Kyle Rittenhouse who had a rifle with him of some kind. I'm not sure the exact weapon, but he was attacked by some protesters. He tried to run away. They hit him over the head. He fell on the floor, and eventually he shot. And I think he killed one of them. And so everyone is screaming about, oh, he's a militia guy. He's a militia guy. And they don't have a clue that the term militia has specific meaning in constitutional law and in American history. So I'm going to ask our guest, Edwin Vieira, to delve into that, starting from the genesis, if you will.
Yes, well, when I talk about militia, I'm talking about those institutions that are part of the governmental structure, both today of the states and of the national government. So you can find references in the Constitution, you can find references in the Bill of Rights, and you can find references in the Constitution and laws of the various states. And this goes back to the colonial period. As the colonies were founded, the king would provide charters to his friends, the people that he had authorized to set up a colony here or there. And part of all of these charters was the requirement that those individuals who were in charge of the colonies would raise and train and arm the people in the colonies to defend the colonies against whom? The king's enemies. And they might be the French, the Dutch, the Spanish, the American Indians, so-called Native Americans, whoever they were. So you had that kind of a structure developing from the very beginning of every colonial charter and every original settlement. And as those settlements developed, they would set up legislatures, and the legislatures would enact statutes, ordinances, whatever they called them at the time. And you find very early on in the 1600s, late part of the 1600s, and certainly throughout the 1700s, various acts and ordinances passed for the purpose of what they called establishing a militia and then regulating it. And in fact, the statutes are often entitled an act for the regulation of the militia of whatever the colony might be. And the basic principle of organization was that everyone from adulthood, and that was approximately 16 or 15 years of age at the time, up to the point at which you were no longer physically capable of functioning because the militia had paramilitary duties to a large extent, was required by law to be enrolled in the militia, to acquire certain types of equipment suitable for militia service, to come out for training and regular discipline and so forth and so on, so that these members of the militia could be called out under usually exigent circumstances to defend the colonies, or in some cases to go off as auxiliaries with the British Army to deal with the French or the Spanish or whatever it might have been. So this structure was implemented statutorily for over a century and almost a century and a half. I think the first militia structure in Massachusetts, 1633, goes way back. And there were literally dozens of these statutes throughout the 13 colonies, all essentially on the same organizational structure. So when the Constitution was ratified. And it talked in the Constitution about these things called the militia of the several states, of which the President of the United States is the commander-in-chief. And then it talked about powers of Congress to organize, arm, discipline, train the militia, and to call forth the militia for certain purposes. Those references were to these pre-existing institutions that existed in each of the 13 states and had existed in each of the 13 colonies going well back into the early settlement period. And the founders knew precisely what these institutions were, because I would venture to say that every one of them either was then a member of a particular state militia, or at some time during his life had been a member of the state militia. He might have been too old, he might have become physically disabled, whatever. But they all had this personal history. And then, of course, most of them were lawyers or were familiar with the laws of the colonies and the states. So they were quite aware of what that legal history was. So if we look at the Constitution, there's no question, when they talk about the militia of the several states, they're talking about these structures in each one of the individual states. So today we would have 50 of them. Take Virginia as an example. The Virginia statute that deals with the militia, at least the first section, talks about the militia of the Commonwealth of Virginia, and that includes everyone from 16 to 55 years of age, male or female, who is able-bodied and a resident of Virginia, a citizen of the United States, or an alien who's taken out the first steps to become a citizen. So it includes essentially the entire population of Virginia that could be mobilized for whatever purposes a militia would serve. And the Constitution tells us the three basic ones. Congress has the power to call forth a militia to do three things: execute the laws of the Union, which is a kind of police function, suppress insurrection, and repel invasions. And repel invasions, of course, a military function. So it's a wide gamut of functions and responsibilities, authority, if you will, that the militia have. Now, our problem today is that that concept of total organization of the population, preparation, and participation by the average citizen in these kinds of institutions has, I would say, it hasn't waned. It was really, to a large extent, suppressed by the political class. About 1903, they began to pass legislation which divided or purported to divide the militia into two categories. One was what we know today as the National Guard. And I'm just going to say, I don't want to cover the National Guard, it's pretty complicated. The National Guard is not really a militia. The National Guard is the state troops that the states can raise with the consent of Congress. It's a separate entity entirely. It comes out of Article 1, Section 10, Clause 3 of the Constitution. But this division happened in 1903, and the National Guard was then focused on by Congress and the states as the primary institution to perform the type of functions that the militia historically performed, but primarily the military function, repelling invasions. And the National Guard is, of course, an adjunct of the Army. That's why in World War I and World War II, you saw all sorts of National Guard divisions and other units going off to the European theater, going off to the Asiatic theater, fighting alongside the Army, fighting alongside the Marines, so forth, as essentially regular troops. Whereas the militia in this country performed essentially no functions, either in World War I or World War II, and it certainly performs essentially no functions today. So that's where we are at the present time. And the great problem that I have always seen in this was those two levels of consideration. One, people's preparation. We have a dearth of preparation at the local level for all sorts of emergency type situations that you could imagine would arise. And I'm talking about typical situations such as hurricanes and tornadoes and other kinds of natural disasters, to situations such as suppression of insurrections, which we see going on today, at least the insurrections are going on today all over the country, and general execution of the laws which the militia could perform and are not performing. And also, because of the absence of this structure in which people would be prepared, there's a lack of participation in the government. The average person participates in the government in only basically one way. He's a voter. He goes and he chooses, or he votes for, a representative, and then that representative goes forth to the local legislature or the Congress or at whatever level he's operating, And he takes over and decides what he's going to propose and what he's going to vote for. And any contact that he may have with his constituents, well, he may be reporting back to them, and the constituents may be calling him up and kind of lobbying to get this or that done. But their direct participation for the average person is extremely limited. If you had a militia structure in this country, there would be constant participation by the average citizen, at least at the local level, in all of those activities which the militia could perform. And if you think of just the first one, execution of the laws, you can imagine a tremendous area for which average citizens could be, how should I say, mobilized, organized, trained, and deployed to perform those kinds of functions, both at the state level, local and state level, because remember, these are state institutions, militia of the several states, but also at the national level, because Congress can call upon them to perform these functions. So let me take one. We had that situation a few years ago out in Nevada with the Bundy Ranch, and the conflict that the Bundys had over their grazing rights, and the Department of the Interior was challenging them on this, and there were various court decisions going back and forth. And eventually you had the notorious, what they called a standoff at the Bundy Ranch, where the armed agents of the Interior Department or some other federal agency came in, and they were confronting the citizenry and so forth and so on. It led to kind of a political brouhaha. And I looked at it and I said, that was a classic example of where if you had the militia, none of those problems would have arisen, because here was an agency, the Department of the Interior. It had certain laws and regulations that it was operating under and enforcing. And the question was, what was the enforcement arm going to be? If the enforcement arm were the militia, Congress delegating to the militia the authority to execute those laws in the local area where the militia actually operated, who would have been dealing with the Bundy family? It would have been the local militia people from that part of Nevada, who would have known the family would have known them. Whatever problems they could have had would have been smoothed over, I would think. It wouldn't have led to a conflict where there were armed people on both sides. But we didn't have that kind of a structure. So the vast mass of people who could have participated in that through the militia, they now became observers. They were watching this on television instead of participating politically and legally in the structure. And all sorts of, well, and unfortunately, or fortunately, they didn't have any kind of violent confrontation, but it came fairly close to that. So there's what I would say is a classic example of where we have departed from this structure, and you can see one of the deleterious effects. Now, our problem today is you have a lot of people who, for one reason or another, are disenchanted with government in general, usually their state government or the national government, and they're going out and forming private so-called militia groups, and I put those in quotation marks, because those people are not constitutional militia, they're not statutory militia, they're simply private groups who have associated themselves with that word for whatever reason. Well, what's in a name? A rose by any other name will smell as sweet. And I guess these people could call themselves the Palace Guard of the Grand Duchess of Gerolstein, and they would have as much right to that as they do to use the term militia. But what they have created is, in the mind of the general public, kind of people who are really ignorant of this history and legal principles, this concept that militia, unquote, is some antagonistic force, some dangerous force, some anti-government force, some anti-social force. And I often talk to people in Virginia and I say, what do you think about militia? And they go, oh, we don't like that idea. That's bad. We don't want militia. And I say, are you between 16 and 55 years of age, male or female, a resident of the Commonwealth of Virginia and able-bodied? And of course they nod their heads yes. I say, well, you're a member of the militia. Did you know that? Did you ever read the statute? And that's the level of, well, insouciance. Maybe it is an ignorance. I mean, people just don't care. It's not a matter that they're ignorant, they couldn't understand it. They just don't care to look this up and study the matter.
Well,
So
as I told you earlier, I mentioned to you before you came on the air, I mentioned to you that people are online telling me that the Constitution doesn't matter because they passed a law abrogating this constitutional precept, and people don't know that the Constitution cannot be abrogated by any law unless it's an amendment to the Constitution.
Well, that's exactly right. And that's the unfortunate situation that we have. People tend to look at our legal system as one that is based upon precedent. That's the difference between our system and the British system. The British system that our founders wanted to get away from was one based upon precedent. So if Parliament passed a new statute, that statute was the law, no matter what the earlier laws may have said. And if a king usurped power and was able to get away with it, that became part of the royal power simply as a matter of precedent. They didn't really have a fixed constitution as we have. They talked about the British Constitution. It was whatever came out of Parliament, whatever the king's prerogative was, sometimes what the judges would rule on, but they didn't have a fixed document that said, these are the limits of power. We're defining the power, and anything that's outside of these definitions, you, the government, cannot exercise. Our Constitution was designed to set those limits. And therefore, there is really no concept of precedent here. Simply because Congress passes some statute that contradicts the Constitution does not mean that that contradiction stands legally. Simply because the Supreme Court makes a decision that contradicts the Constitution does not mean that that Supreme Court decision supersedes the Constitution. Our difficulty is a lot of people think that that's the way it actually operates. They're thinking in terms of the British Constitution instead of the American Constitution.
Well, you gave me a great segue into another subject which came up a lot in the last few weeks, and that's this whole idea of stare decisis, and the whole idea that a Supreme Court judge is obligated to follow the decisions of prior Supreme Court cases. And in fact, when Kavanaugh was being interviewed for the judgeship, he said that Roe v. Wade is settled law. And of course, they taught most of us in school. You're a little bit older than me, so I don't know what you were taught. We were taught in law school that a Supreme Court decision is the law of the land, quote, unquote. So maybe you can go into that, delve a little into that. And is a Supreme Court decision the law of the land?
Well, that's the famous or infamous Cooper versus Aaron decision where Justice Brennan makes that statement. A decision of this court on the Constitution is the supreme law of the land because we, the judges, are the final interpreters. Now, of course, the judges are not the final interpreters if you really look this thing up, because Congress can do various things, the president can do various things, eventually the people can do various things. The people are the final determiners of what the Constitution actually means. But that concept is one, the stare decisis concept is one that goes way back in common law, because the idea was you don't want to upset a long line of decisions upon which people have come to rely simply because you get some new bee in your bonnet. The judges are supposed to weigh this line of earlier decisions before they make any changes. Now, it never meant that you couldn't change a line of decision if you considered that it had based on the wrong principle, or it had gotten the facts wrong, or whatever. There are all sorts of reasons why stare decisis would be set aside. And the interesting thing in the constitutional field, you will find many judges have said this, justices have said this, that stare decisis applies with least authority in constitutional cases because of the extreme difficulty of amending the Constitution. That is, if you treated a Supreme Court decision as the Constitution, the only way to get around it would be to amend the Constitution. So even the justices of the Supreme Court have recognized, well, given that that's the situation, when we have a constitutional question before us, we really have to be very careful about applying stare decisis. We can't do that mechanically. We have to think this thing through, because ultimately it's the Constitution that determines whether our decisions are correct. It's not our decisions that determine what the Constitution means. That's the important factor here. Now, I think in many instances, it's a political decision on the part of some of these justices, especially when they're standing up for confirmation. I remember Bork, they asked him a question about the legal tender cases of the 1870s. And did he consider that those right or wrong? He said, well, they're wrong, but there's nothing we can do about them now, because he didn't want to get into a shouting match with senators over how far he would go. And I think that's the same with Roe versus Wade and some of these other Planned Parenthood versus Casey, some of these other abortion decisions, when the justice is sitting there before a hostile Senate committee, perhaps the last thing he wants to do is to indicate that he intends to look at those decisions through clear-eyed glasses, as opposed to simply mechanically following them. And I think that's a political statement that they make. They're very careful in the confirmation hearings not to commit themselves to anything. The difficulty becomes when they become justices, will they now look at those earlier decisions, aligning them with the Constitution to see if they in fact do align or not? That's the real problem.
I see.
I mean, if I were a Supreme Court justice, in any constitutional decision that came up, I would either be writing a majority opinion or a concurring opinion, or more likely a dissenting opinion, right? I run into a lot of cases I can imagine I would dissent against the opinion of the Supreme Court, because that's really their duty. It's not simply to follow what somebody else. We don't stumble over an earlier decision, an earlier question, simply because other people have stumbled over before. All right.
It seems to me that the only justice that comes within striking distance of what you're saying would be Clarence Thomas.
Mm-hmm.
I don't think, as far as I know, that I've seen anything from any of the other justices that come even close to that. And unless you have, maybe you read a dissent and that I never noticed, but Thomas is the only one who seems to stick to the Constitution. And I'm amazed that he was appointed by Bush. Shocking to me, because he would have been the last president I would have figured would appoint a fellow like Thomas.
If they had only known how Thomas was going to turn out, he never would have been nominated.
That's what I'm thinking.
I think that's exactly that's right.
Now, on this issue of the next justice, first of all, what did you think of Ruth Bader Ginsburg as a judge? Not getting into personality, but as a judge, and her fealty to the Constitution or the lack thereof.
Well, I doubt that she had a general fealty to the Constitution in the sense that the founders did. She was very much a quote-unquote living constitutional jurist. She wanted to somehow incorporate or interpolate into the Constitution modern-day concepts that the framers, I think, would have looked askance at. I think at one point she said something to the effect that she thought that in a constitutional case, she would look to the Constitution of South Africa as having principles that she thought would be more applicable in our modern situation than our own Constitution. So that tells you that she was, how shall I say, divorced from an originalist approach to the Constitution, trying to find out what it meant when it was written, what it meant to the framers, or more importantly, what it meant to the average American. She came out with a couple of good decisions. I mean, you can't fault the woman for being entirely wrong, all right? She had some positions in which I thought she had taken the right line. But generally, she was a loose constructionist and, in a sense, an anti-constitutionalist, because she was willing to, as I say, interpolate concepts which are really foreign to the constitutional structure and constitutional ethos.
When you said she was divorced from those principles, I was thinking she was never married to them in the first place.
Well, but if you look at some of the civil libertarian decisions that she either wrote or she concurred in them, and you say, well, yes, in some areas that's fine, but in others, no. Now, I had only one instance in a case before her, and she asked a question of a co-counsel who was standing there, my co-counsel, and it was apparent to me that she hadn't read the briefs very carefully. It was a question that was just, it was like off in left field somewhere on this case. Now, I don't necessarily fault her for that, because you see that quite often. They have a huge workload, so they can't be right up to date. And maybe it was the clerk that gave her the question to read. But the only instance I ever had a personal connection with her, she seemed not to be really on the ball in that particular case. All right, the question now arises, though, she's gone. who and when will she be, by whom and when will she be replaced? And you have this argument that, well, her last wish communicated to who knows whom was that she wanted her decision on her replacement to be put off until the next president was inaugurated. I guess she hoping that that might be Mr. Biden. But of course, the Constitution makes no provision for that type of situation where the last wishes of a justice somehow become controlling on the process. That wasn't Ruth Bader Ginsburg's seat in the Supreme Court. That's just a seat in the Supreme Court. And the president can nominate and the Senate can confirm, tomorrow morning if they really want to. That becomes a political question as to what they think the consequences of moving too fast or too slowly may be.
The story is now that supposedly it's between the Justice Amy Barrett, I believe her name is, and a Cuban jurist. I think her name is Lago or something to that effect. And I remember reading something that Amy Barrett said where she stated that I follow precedent if the precedent is correct. And when I heard that, I was kind of encouraged because I'm not used to hearing a remark like that. But I know very little else about her. Do you have any particular knowledge beyond that?
No, I'm trying to try and find some of the opinions that she's written when she was on is on circuit court, and see what her attitudes are. Especially with, the thing that always worries me about these people is they say, well, we may or may not follow precedent, but they tend to follow these tests that the Supreme Court has invented. And way back in the 60s, maybe even a little earlier than that, they invented what they call the compelling state interest and government interest test, which essentially says that if you have a statute, let's say, and someone challenges this statute on the basis that it's violating whatever amendment, First Amendment, the government can come in and say, well, there's a compelling reason for us to do this, and that overrides your First Amendment right. Well, the Constitution has no asterisk by the First Amendment or any other provision that says if the government comes up with a compelling reason, we can just forget the limitation here. And that was invented entirely by the Supreme Court. And what it really amounts to is the ability of the Supreme Court ultimately to decide when and under what circumstances it wants to circumvent a constitutional limitation. And you had in the Heller case, the firearms case, Second Amendment case coming out of the District of Columbia, at one point in Justice Scalia's decision, he says, with respect to the Second Amendment, we can't use one of these, what they call balancing tests, balance the compelling interest of the government versus the interest of the individual in that Bill of Rights liberty. We can't use that. Balancing tests should not be applied to fundamental liberties, and that's absolutely correct. And that's kind of a by-the-way statement in a very long opinion.
Well,
and so
balancing tests sound more like a legislative.
Well, it is. I mean, basically that's it, because when they look at this concept of compelling, well, compelling to whom? On what basis, right? It's kind of non-scientific because there's no standard, right? In science, we can weigh two things and say, well, this one weighs more than that one because the needle is moving on the scale. When you're talking about compelling state interest, it's compelling in the minds of 5 of the 9 justices. And if you had another set of 9, the compulsion might be the other way. It's really non-scientific. It's non-verifiable. It's non-falsifiable. It can't be subject to experiment. The whole thing is nonsense. They invented this. That's why I say they invented this long ago. You can't find it in the Constitution. And I'm hoping that some judges will follow that Scalia lead. I can't recall whether Thomas ever said something along that line and say, wait a minute, this whole compelling interest test is totally illegitimate. We have to rethink what we're doing here, certainly when we're dealing with the Bill of Rights and also perhaps with other limitations that are in the original Constitution. We can't simply say we're going to follow somebody's view of a compelling interest, because then what happens ultimately? The government decides what its powers are. Whether it's the legislature doing it and the court agreeing, or the court doing it, 5 of the 9 doing it, It's some governmental entity or governmental individual, that fifth justice, who decides what the limitations on the government's powers are. And that's contrary to what? To the whole constitutional concept of delegated powers. The Constitution determines that, not the governmental entity, not the governmental agents, but the Constitution determines it. So I can see how they got themselves into this trap. But the point is, now I would hope they begin to think how we're going to get out of it and return to the Constitution. Thomas is one. Scalia, of course, is dead. I'm not sure about Gorsuch and
I was very disturbed
Roberts.
by his funeral home decision.
Yeah. So,
There
you know, so when you tell me that she has said, Barrett, I think it's her name, Amy Barrett.
Yeah.
She has said that she's not going to be, or she's not going to allow herself to be handcuffed by precedents. Well, that gives me a certain feeling of hope, right? That's what you want, because some of these precedents show up and they need to be reviewed. I think of the compulsory vaccination one, which is being tossed around now, Jacobson versus Massachusetts, 1905 decision based on smallpox and so on. Scientifically, where is 1905 from today? And yet you find people like Dershowitz. He was on a debate with Robert F. Kennedy Jr. over the question of mandatory vaccination. And Dershowitz simply cited that. So well, that's the Supreme Court. That's the end of it. Supreme Court said 1905, you have to have a mandatory vaccination. Actually, it didn't say that. It said that Jacobson had to pay a $5 fine. They didn't end up vaccinating. They had to pay a fine. But here's Dershowitz. Now, how long was he a Harvard law professor? Eons. I mean, you're talking maybe a generation or more. He was a Harvard law professor, right? And yet there he is adopting this concept that we're going to take an opinion that scientifically is coming almost from the dark ages. And that is going to be applied today to a completely different situation, simply because it's a quote unquote precedent. Well, maybe under the British Constitution, but not under the American Constitution.
I conjecture that the reason this is all happening in this country at every level, whether it's the Supreme Court or the government, whether it's a Harvard professor, I think we've gotten to the point now where the people who are attracted to power, because years ago, the government had less power than it has now. I thought it had too much from the beginning, but that's just my opinion. But certainly, you have to be really naive to think that the government is less powerful now. And I think because of that, you attract psychopaths to seek that power. Mm-hmm. And they think that they're literally gods. I mean, look what's happening with Ruth Bader Ginsburg. She's lying in state. I mean, forget about the fact that technically she was Jewish, and that's a total violation of Jewish law on burying the dead physical body, because it has to be done as quickly as possible. And you don't lie in state as a Jew. And besides that, I mean, there were other jurists that have died, and I've never seen anything like this. This is bigger than Babe Ruth.
Well, Scalia didn't lie in state, did he?
No.
I don't recall that, no.
And she's being buried in Arlington Cemetery. That's what it said, which is not really very kosher. But nevertheless, I just see in everything happening that people literally think that they're God. And anyone who professes to believe in God, and I can't search men's souls, but this Amy Coney Barrett now is being attacked and castigated by all the usual idiots, you know, in social media and elsewhere, saying that she's part of a cult. Now, as far as I know, she's a Catholic. And, you know, if they called any other group a cult or that kind of name, they'd be called bigoted and Catholicophobic or homophobic or genderphobic, but they're making all these statements about her. And it's ironic because they claim that her so-called cult believes in a woman being obedient to her husband. I haven't seen that too much around lately, but allegedly that's the allegation. But if you look in the book of Genesis, it's pretty interesting, you know, when Eve transgresses and God admonishes her and says that because you have basically gone against what I told you to do, you're not gonna live forever. I'm gonna give you pain in childbirth. And from what I've seen, being in 3 delivery rooms in my life, they certainly have a lot of pain. They grabbed my hand so tight, I thought they were gonna break my wrist. And also said, you will be dominated by your husband. That's what it says. Mm-hmm. So, you know, it doesn't matter whether I agree with the Bible. Everyone is entitled to either agree with it or disagree with it, or agree with whatever part they want to agree with. That's their freedom. But to criticize somebody for believing what the Bible says would be called bigotry if it's in any other domain.
Oh, yes, and it's quite uncertain that a case would ever come before her in which she would use some religious test as the basis for a decision given the First Amendment, right?
Yeah.
Sure. So she can believe whatever she wants. She can be Catholic, she can be Buddhist, or, you know, whatever. You pick your particular religious philosophy. But you look at the constitutional structure and say, well, how would that play in some way to decisions that she would make, especially given that there are 8 other members of the Supreme Court with her. But one thing you said earlier, Bob, you said, well, you know, our government has all this expanded power. And I like to say to people, no, the government has exactly the same powers it had when the Constitution was ratified. You have a lot of usurpation. You have a lot of aspiration to tyranny on behalf of public officials. And some of that has worked its way into that magic word, precedent. They did it before, so they can do it again. And we haven't gone and cleaned out the stable of all of those precedents. And we can't imagine that the Supreme Court would ever be able to do that, because you know how cases come to the Supreme Court very slowly, and they pick and they choose, and the issues aren't always suitable to an across-the-board determination on any particular subject. It has to be done at a legislative level, or in some instances by the execution of the president's powers. But really it comes back to the people. We have to look and say, wait a minute, this structure that we have has become encrusted with political concepts that have no basis or justification in this document, which is the basis of authority for this structure. That's what has to be changed. And who is supposed to do that changing? Declaration of Independence tells us it's the people who have always retained the right to alter or to abolish any governmental form that is not serving its proper purposes. So it comes back to the American people ultimately. The lawyers aren't going to do it. The politicians, heaven knows they're not going to do it because they're very happy with the system they have now. The pressure has to come from below, right? Like a volcano. We have to have the pressure build up and build up and build up. So at the higher levels realize we have to stop doing what we're doing. And then we have to weed out, as you said, the psychopaths. Did you ever read that book, Political Ponerology?
No.
By the Polish psychiatrist?
I read Death by Government by Rummel.
Oh, well, okay. Well, we know the 100 million people when he wrote had been killed by tyrannical government.
Right.
But I think it's called Lowajuski or something along that line. He has a Polish name, but the book is Political Ponerology. You can't miss the title. It's on Amazon. And that is basically his thesis. He says that there are certain kinds of institutions which, like magnets, draw the psychopathic personality in because they give the psychopathic personality the ability to exercise dominion, to exercise power, to work, to use his narcissism, you know, exploit his own narcissism. And government is one of those. The military is one of those. Big corporations, to a large extent, are one of those. Maybe your own homeowners association, depending on who your neighbors are, could be Absolutely. One of those, right? Wherever you put a group together that's sufficiently large, and there's an ability for members of that group to gain power over others, the possibility of psychopathological tendencies to work their way into the operation goes up. And this political ponerology book says, well, we can analyze this in psychiatric terms. And when we do that, we find there's this problem, there's this problem, this problem, so that we have to deal with those problems. Now, I don't agree with him because he tells us that the people who should be doing the final decision-making are the psychiatrists. and the way he's described this, I would say, well, psychiatry is a place where political ponerology would be applicable. The psychopaths would be going there, right? Right. So we have this problem. Who is going to guard the guardians, right? Remember the ancient Roman statement, who's going to guard the guardians? And that's the whole, when we come back to the militia concept, that the ultimate power in any polity, in any society organized politically, is, and there are two of them, there's the power of the purse, money, you have to have money to do anything, and the power of the sword. Who has the ultimate force in his hands?
The famous quote from Mao.
Political power goes out of the barrel of a gun. All right? Okay. Mao was a terrible person, but some of the things he said were correct. Right? Yep. Even Stalin, you name your dictator, some of the things they said were correct. They did have an insight here and there. And that's ultimately the modern version of the ultimate concept of sovereignty the founding fathers were attached to. The power of the sword, that's the way they talked about it. The power of the sword should be in the hands of the sovereign. Who's the sovereign in the United States? It's the people themselves. How can they exercise the power of the sword? Well, not through a standing army, because the founding fathers, we know, were desperately afraid and suspicious of standing armies. It was to be done through the militia. Everyone organized in this structure, which would have sufficient force at hand to deal with foreign enemies, repel invasions, to deal with insurrections, suppress insurrections, to execute the laws against lawbreakers, and to supervise and keep control over what? The standing army. Because the Constitution does provide for an army and a navy. Congress can raise and support armies, and it has been doing it since the very beginning. What it hasn't done since 1903 is to continue the militia structure so there would be that ultimate check and balance. And number two, the people would be participating in this institution. They would realize what their real place is in our political system. It's not simply to be a voter every 2 years or 4 years or 6 years, whatever the term of the particular office is. It's not simply to be watching what your representatives are doing and cursing because they're doing the thing you don't want them to do. It's participating in an institution in which you personally have governmental authority. The militia is a governmental institution. And I can see why the politicians at the turn of the 20th century wanted to get rid of this. Remember, the turn of the 20th century, they were, let me say, intoxicated with the idea of expertise in government. You have the whole administrative state developing. Wilson administration during World War I, and then Roosevelt greatly expands it. And the concept was, society is too complicated to be run by some kind of Republican form of government. We need experts. And what we need to do is to create expert agencies in each of the areas that we think are important. And Congress's duty will be to create these agencies, create the statutes, give them the power, delegate them the authority, and then fund them. And the agencies will then go on and they'll write regulations and they'll enforce these regulations. And the purpose of the people will simply be to elect congressmen who will play into this administrative state structure. Okay? And ultimately, the administrators will be running the country because only the administrators have the expertise to do it. We can't depend upon the people. They're too stupid. We can't depend upon Congress. That's a big committee. They never get anything done. We have to put it in the hands of people who can write their own regulations, can enforce their own regulations, and who know what the heck they're doing. And that's how this government that you're talking about, the government of usurpation, has expanded. And the average person looks at this structure and says, I can't understand what's going on there. I have to listen to Dr. Fauci. I have to listen to people from the Pentagon. I mean, you pick your agency. I have to listen to the Department of Interior, Health and Human Services, Department of Education, whatever it is. I have to listen to them because I don't understand it. Oh, and by the way, I can't get control of it because even Congress can't get control of it.
And the reason they can't understand it is because of the Department of Education, which dumbed them down to begin with.
Yeah, well, I think some of these people have an innate problem. It wasn't so much the school they went to. I mean, any school they've gone. but there's the situation, and the politicians love this, the agencies love this, and the courts have essentially washed their hands of this by saying, well, we're going to defer to agency determinations in most cases because the agencies are obviously the experts. We don't understand. We're just judges. What can we do? So they shrug their shoulders. And there's our difficulty.
A more obvious case is when George Bush announced that we're going into Iraq, and he said, we're going in to enforce a UN resolution. Since when is the president the chief executive to execute the laws of the United Nations? I mean, this is the kind of overreach we're talking about. And, you know, I always talk, whenever I speak to an intelligent leftist, which is usually an oxymoron, but every once in a while, there are certain leftists who at least have some intellectual integrity, guys like Matt Taibbi, or even this fellow who was helping Snowden, Glenn Greenwald. I disagree with him on almost everything, but he at least has an understanding of the kind of corrupt government we have. He's not a lover of government per se, but I always tell these people, you make all these cogent observations about the corruption of government, and what is your solution? You want them even more power. And the contradiction of that is completely insane. And the same thing is true of many people who call themselves Republicans. They want to give Trump or someone else the kind of power they wouldn't give to Hillary Clinton in a million years. And they can't even see beyond their own nose that by giving that kind of power to a Trump or a Bush or anyone else, you are giving that power to a Hillary Clinton.
That's right. Well, it's very much along the lines of the socialists and the communists. You confront them and you say, well, you had communism in the Soviet Union, you had communism in Red China, you still have it. You have communism in North Korea, all these places, Pol Pot in Cambodia, right, Venezuela. It's always failed. And they say, well, that's simply because they were doing it wrong.
Yeah.
If I and my friends become the leaders of the new communist movement, we'll make it work. Okay.
It's like Colonel Sanders. We do communism right.
Right.
And right.
That's right. That's right. It all depends on your state of mind, right? You have a machine that mechanically can't function. In fact, will chew you up because it works backwards. But the state of mind of the person holding the levers will change the situation entirely.
Exactly.
And that goes back to the political ponerology, the psychopath point. These people all believe, all narcissists, and they believe that if once they gain the power, they'll be able to do what they think is right. They're not so concerned about what you think is right, but what they think is right. It all comes back to that. And there's the grave difficulty because, as this Polish psychiatrist points out, many of those people are very difficult to diagnose. You know what I mean? When you're dealing with them.
Right.
It's only when they get into a position where they can exploit and abuse that authority that you discover what you're really dealing with. I think that's true of a lot of these lockdowns that we had during this early part of the COVID business. Out of the woodwork came the totalitarian mindset in many of these governors, in many of the public health officials working under them, and we saw how far they were willing to go when you release the reins. Look at what's happening in Victoria in Australia, the province of Victoria in Australia. They're having exactly that problem right now with this socialist premier or whatever his exact title is. They can't get rid of him because his term still has a number of years to run. And almost every day he's implementing or threatening some more draconian measure than he had put in the day before.
As my father used to say, and he's been dead since 1976, but I remember him saying this all the time, when you think there is no God, you think you are God.
Mm-hmm. That's right.
And that's
Anything
what really
is possible. Anything is possible under those circumstances, especially to me, the psychopathic, narcissistic personality.
Exactly, exactly. Well, I've got to get running because my Zoom time is going to run out. It's always a great pleasure to have you on. I know it's
Well,
always
thank you, Bob.
great pressure to talk to me, but you, it's a pleasure.
No, I love it. I certainly hope we can have another one of these someday.
Absolutely. We will do this time and time again. It'll be like Elizabeth Taylor's marriages. Funny.
I hope a little more successful than that.
I hope so too. Well, thanks a lot and God bless.
Okay, thank you, Bob.
Take care. Bye-bye.